Ladies and gentlemen, welcome back to the Indie Zone. My name is Kathy. It was 1 year ago on July 2nd, 2025, when Brian C. Koberger stood up in open court in Judge Stephen J. Hippler's courtroom and changed his plea from not guilty to guilty of the 5 very serious felonies that he was scheduled to stand trial for in August of 2025. Not only did he plead guilty, give up his right to a jury trial, but he also waived his appellate rights in his written plea deal with Idaho, meaning that he, in writing, agreed that he would not appeal what had happened in the case to a higher court. But as Judge Hippler noted last July, the fact that Mr. Koberger pled guilty did not mean that there would not be the possibility of a potential appeal, and he cited specifically to a Supreme Court of the United States case of Garza versus Idaho, that there would be a possibility for that person to challenge what had happened in court even when an appeal waiver is signed. On June 18, 2026, the Supreme Court entertained another case dealing with appellate waivers called Hunter versus United States. And this was a case where Mr. Hunter had also signed an appeal waiver. And when he tried to appeal his sentence to the United States Court of Appeals for the Fifth Circuit, his appeal was denied on the grounds of that appellate waiver. Well, the matter eventually made its way to the U.S. Supreme Court, where on June 18th, the Supreme Court, in a resounding 8-1 decision, indicated that there are certain grounds where a party who signs away appeal waivers may still go on and challenge their sentence or their conviction if they can show a miscarriage of justice. Justice Neil Gorsuch, who was one of the 9 justices who voted in favor of the miscarriage of justice standard, went on and he wrote a concurring opinion to raise additional issues that he felt were important. He emphasized that the appeal waiver issue, which appears to be becoming more and more common in the United States, is a broader problem that's involved. He is quoted as saying in his concurring opinion, "In our times, the jury trial has given way to a conveyor belt of plea bargains," end of quote. And there is the additional issue, a scenario that would have been a problem for the framers of the Constitution, who saw jury trials as an essential safeguard against tyranny. He wrote that, quote, "When confronted with coercive prosecutional tactics designed to induce defendants to take plea deals, the court has often condoned those practices or let them pass in silence." So he took the time and effort, that is Justice Gorsuch, to add these additional points concerning his issues with appellate waivers. As of this time, Mr. Koberger has not gone on to challenge his sentence or his conviction formally. There still is time. He has a year to do so under the Idaho statute that would allow a person to challenge post-conviction relief. And if you would like to read Justice Gorsuch's opinion in concurrence with the majority, I've given a link to the SCOTUS website where you can read the majority opinion and also the Gorsuch concurring opinion. Is this issue of appellate waivers, which is becoming more and more prevalent in this country, a sign of a bigger problem as we, in 2 days, get ready to celebrate the 250th anniversary of our nation's birth. Until next time, this is Kathy. Thank you for joining us here today.